Andrew from MERS again.
Yes, I'm wondering exactly what you're looking for from the legislature regarding the regulation of dark money 501c C4s. What is this bill that will be introduced? What is that going to do exactly on a state level? And I know a lot of these problems extend up into the federal level too. So I mean, is this going to be stymied by that? I mean, what's the situation with that?
Well, first, I believe it's Representative Jolie Brixey who's introduced legislation to require lawmakers to register their C3s and C4s with our departments when they create them. That enables, I believe, the provision of a link between a lawmaker and a C3 and C4 to be public. And then, yes, as you know, on the federal level, there are disclosure requirements for C3s and C4s on an annual basis. Now, do we need more disclosure of those C3s and C4s? Yes, we're working towards that direction, and certainly this Brixey bill and the other aspects of the BRIGHT Act are an important step in that direction.
That's all the hands.
Thank you all.
Claire just put her hand.
Claire?
Yes. One last question, if I may. Secretary Benson, Attorney General Nessel seemed to indicate that some of the donors to the Peninsula Fund were aware that they were paying for Lee Chatfield's personal expenses. So I'm hoping you can kind of talk to the potential need to update campaign finance laws to create greater accountability for donors and what that would look like.
Yeah, I think it reveals a certain need to make sure that these entities are not used as workarounds for private funding or funding unrelated to the mission and purpose of the statement of organization and the organization itself, be it a C3 or C4. I expect that and have confidence that the Attorney General will be looking at all potential misuses of funding at every level. But it shouldn't be lost on us that to the extent that there was an effort to use these entities to work around or to enable any sort of quid pro quo corruption or pay-to-play level of payments being shared, that should be revealed. And then if our current laws don't enable that to be revealed, then they need to be changed.
Sheldon Krause.
Hi, Sheldon.
Hey there. Perfect. Yeah. So Sheldon Krause, 9 and 10 News. Attorney General Nessel earlier today had some pretty harsh words for the Michigan Campaign Finance Act. Specifically, she said that the act was effectively useless and utterly worthless as a deterrent for these crimes. So just wondering your thoughts on that piece of legislation specifically, and if you agree with those thoughts from Attorney General.
Well, as one of the chief enforcers of that provision, I've certainly found its inadequacy to be startling. In particular, the fact that our office does not have subpoena power, that we have to essentially enable or allow for serendipitous revelations like the one in this case to enable any sort of revelation that wrongdoing occurred to enable accountability, strikes at the heart of what the mission of the Michigan Campaign Finance Act is actually supposed to do, which is to regulate public funds and to ensure that when money is raised to a certain purpose, particularly in entities that fall under the Act, that the money is spent in furtherance of that purpose. So I agree with the Attorney General that the Michigan Campaign Finance Act is in dire need of modernization, in furtherance of greater transparency, and also in furtherance of greater enforcement abilities from our office to be able to track down, require evidence to be conducted. We currently do not have
something to do.
And
Pass
others
back at your desk where I can give them to you right now. What's your preference?
will enable us to ensure full accountability of any provisions of the fact that are violated.
With the last question, Jonathan Osteen.
Hi, Jonathan.
Yeah, hi, Secretary Benson. Just real quick, with regulating nonprofits, are you at all concerned the state could run up against free speech arguments that if you attempt too aggressively to regulate nonprofits?
Of course, you always have to strike a balance between the protections of the First Amendment and the very clear public interest against corruption. It's a public interest that the U.S. Supreme Court itself has identified as something that could enable regulation of public funds and campaign funds, because the public does have an interest in ensuring that those making laws on their behalf and serving in legislators on their behalf are limited and held to higher standards, and in particular, that the institutions they run are protected against corruption. And so when it comes to the compelling government interest of corruption, there are opportunities to regulate funds like this and require disclosure of them. The Supreme Court has made that clear. But certainly any type of lawmaking around this issue needs to be sensitive to First Amendment protections and also privacy concerns as well. All of it can be managed, though several other states and the federal government have stronger laws than we do in this regard. And so that in and of itself underscores that we can do better, that most other states do better. And my hope is that under the current leadership in our state house and the state senate, we will do better. Thanks, everyone.
Thank you, Secretary Benson.